India is missing Mr. Gopal Subramaniam.
Yes, but he could possibly argue from on virtual courts,
I
right?
know, I know.
Just trying to
We are
catch
live,
up
sir.
with.
Sorry, you were saying something?
No, go on.
No,
Let's
I
start.
was.
We are live, sir.
Okay, great.
Good afternoon, good evening, and good morning to all those turning in. My name is Ankit Malhotra. I am the president and co-founder of the Jindal Society of International Law. We today have amongst us a stalwart of professionals and of caliber unparalleled. I will not take much time and share what the society is about, but I would like to dedicate this moment to someone who has inspired me and also the entire international and also domestic legal community. We have been inspired immensely by Mr. Soli Sorabjee. My father and uncle penned their thoughts in Mr. Sorabjee's book. This is a book written on him, and I share it here for everyone. And I would like to share two paragraphs from this. My father wrote, as a lawyer, I shared with him fond memories, international conferences, venues over the globe, court appearances, events at IIC, book releases, discussions, seminars, engaging dialogues, and creative writing. We have shared umpteen platforms. All our 8 books have merged with his blessings. Always an encouragement, a pat on the back, a foreword, a preface, a book release speech. He has never missed an event for us. Never a no. His thoughts, insights, and views have always ignited our academic writing and professional goals. To this and to others, my uncle wrote certain episodes and hilarious moments from our travels to so many countries are firmly chiseled and etched in our memory box. A travel diary compendium can well be put together. And one such instance was when my uncle was traveling with Mr. Sorabjee, and a diplomat came and asked for Mr. Sorabjee's passport and adjusted his passport. The diplomat took his time to return, and in the interim, I remember my uncle sharing with me that Soli Sorabjee uncle remarked that the justice is now stateless. Now, with those words, I invite our Vice Chancellor, Professor Dr. Rajkumar, to please share a few words. Professor Rajkumar is the leading source of inspiration to all of us present over here, to our students and also to us professors. Sir, the floor is yours.
Thank you very much, Ankit, and also to the General Society of International Law, as well as all our partnering organizations. It's so wonderful. I just see Zia Modi present. Wonderful to see you, Zia, and of course, Zena Sorabjee ji. And thank you very much for Mr. Gopal Subramaniam to be present here on this occasion. Thank you, Ambassador Rajamani itself. You know, in fact, one of the remarkable things about Mr. Sorabjee is that he had this extraordinary ability to connect with people from all walks of life and not just limited by law, and also who could transcend age, time, and space. This is something that I had the privilege to know him, and everybody who has connected with him in his life would tell you. So my own connects with him dates back to, I know this precise date. It was literally 13th December 1997. That was when Mr. Sorabjee was the chairman of the Rhodes Scholarship Selection Committee, which selected me as a Rhodes Scholar. And I met him for the first time, although I met him, or rather seen him from distance as a student in Delhi University. But Mr. Sorabjee was the chairman of the Rhodes Scholarship Selection Committee, and he had this extraordinary ability to engage on a one-on-one dialogue on issues, and then would actually end up bringing the best out of you in his own manner. So he was a natural teacher, a mentor, somebody who was so deeply connected to law, but would never hesitate to, mentor the other, particularly where students are concerned, and yet make you feel very important. And that's another extraordinary quality of him. And then later, a couple of years later, I had the privilege to welcome him to Harvard Law School. That was April 2000 in Boston. He was serving as Attorney General of India, and he had come. We had this important conference on human rights and Indian judiciary's constitutional jurisprudence. We had Justice V.R. Krishna here, and Mark Galanter and Granville Austin and so many others. And Sorabjee was there, and he simply mesmerized everybody present there. And suddenly, Harvard Law School saw this huge presence of Indian jurisprudence echoing in the speech of Mr. Sorabjee and others. So, of course, since then, we've had very long and deep association with him. At the earliest days of the founding of O.P. Jindal Global University and Jindal Global Law School, 11th, 12th, and 13th of August 2006, Mr. Sorabjee spoke at the first conference. So I can go on and on about this man. We all know about his contributions when it comes to advancing the cause of human rights, freedom of speech and expression, issues relating to public international law, as well as the relationship between international law and domestic law, which Mr. Subramaniam is going to speak. So I can only say that he was always ahead of his time. He had so much of dignity and magnanimity when it comes to engaging with people whom he disagreed. And such was his civility in his engagement that every bit of his life was deeply inspiring, and he never hesitated to inspire. During COVID-19, as early as February 2020, when we were celebrating my wife Pratibha's birthday, I have a beautiful photograph from it. He came, we had hosted that function at Shashi Tharoor's home, and in his wheelchair, he came, spent an hour and a half with us, and enjoyed every bit of it, met people. This man had so much life in him that he could just be there for more. And that's one of the things that I feel bad that I couldn't spend more time with him, because it was never enough. So I want to stop here. I want to say what an extraordinary man he was. His life and legacy is a true inspiration for everybody whose lives he had touched and who touched his own life. We could not have had a better individual in Mr. Gopal Subramaniam, who himself is a great source of inspiration for me to reflect about the life and contribution of Mr. Sorabjee. These are all individuals who have shaped and now are also shaping the future of law and justice. And I'm grateful to Mr. Subramaniam for accepting our invitation. Thank you, Ms. Zina Sorabjee. Thank you for the books. We are celebrating the Soli Sorabjee Library on our campus. I look forward to bringing you to our campus to personally witness the presence of him in the portals of our library. And I look forward to hosting you as well. And of course, Zia has been our earliest ambassador. I always tell that even before I discussed with Mr. Naveen Jindal the idea of this university, I discussed with Zia, and Zia was believed in it long before the world believed in us. So thank you to all of you, and it's so good for us to be able to do this.
From one ambassador to another ambassador, I now invite our eminent scholar, as Mr. Subramaniam said, Mr. Venu Rajmani. Professor Ambassador Venu Rajmani is a clear diplomat, and he's a scholar of international relations and a former journalist. He was ambassador of India to Netherlands from 2017 to 2020. He was also the permanent representative of India to the Organization for Prohibition on Chemical Weapons in The Hague. He appeared on behalf of India before the International Court of Justice in the matter of the advisory opinion concerning the legal consequences of the separation of the Chagos archipelago from Mauritius. He was a member of the Indian delegation before the International Court of Justice in the Jadhav case and co-agent of India in the Enrica Lexi case. Sir, I invite you. Thank you so much, sir.
Thank you, Ankit. Vice Chancellor, Professor Rajkumar, Mrs. Soli Sorabjee, Mrs. Sia Modi, Mr. Gopal Subramaniam, friends. I'm grateful to the Jindal Society of International Law for having invited me today to share a few reminiscences of my times with Mr. Sorabjee. I speak today with a sense of great honor at having had this opportunity to say a few words about one of the brightest legal luminaries that India has produced. At the same time, I speak with a sense of sadness for Mr. Sorabjee. Soli, as he used to be lovingly called by everyone, is no longer with us. My association with Soli began in Geneva when I used to be a young diplomat responsible for human rights and humanitarian affairs in the United Nations. It was in that period that Mr. Sorabjee was first appointed by the UN High Commissioner for Human Rights as Special Rapporteur for Nigeria. And subsequently, he became a member of the Subcommission for Prevention of Discrimination Against Minorities. He served several years in the Subcommission, and he went on to also chair the Subcommission. In these years, Mr. Sorabjee was a regular visitor to Geneva, and I had many occasions to spend time with him in the United Nations, in the Palais de Nation, which was once the headquarters of the League of Nations, and to join him in many meetings there. And I'm extremely happy to tell all of you of what an impression that he made on all the diplomats, on all the legal scholars and the human rights experts who used to gather there, not to mention the High Commissioner for Human Rights. Mr. Sorabjee impressed everyone with both his passion for human rights as well as his sheer legal brilliance, his knowledge of jurisprudence. And he had a very major role to play in pushing Nigeria, which had become a military dictatorship, onto the path of constitutionalism, back onto the path of democracy through his role as Special Rapporteur for Nigeria under the UN Commission on Human Rights. Mr. Sorabjee was also a frequent visitor to our home. After all the human rights meetings, I discovered what a wonderful human being he was, his great passion for food, his sense of humor, one can say sometimes his impish sense of humor or naughty sense of humor, his empathy for all around, his enormous grace, his humility, and more than anything else, his support for the young, his support for the youth, and his encouragement of everyone who was interested in law. I myself used to often speak to him about my interest in law and the fact that I come from a family of lawyers, and he would do everything possible to encourage me to return to the field of law as soon as I can once I finish my diplomatic career. And I'm sure he would have been very happy if he knew that I'm today a professor of diplomatic practice at the Jindal Global Law School. Mr. Sorabjee touched everyone that he met. He impressed everyone that he met, and in many ways, he was unforgettable. And as Dr. Rajkumar was just now reminiscing, I too recall that the last time I met him was probably at Hindustan Times annual summit, which is held in Delhi, when he was there on his wheelchair, but not giving up, full of the joy, the vivre, enjoying every moment of it, enjoying the fact that people were coming up to him one after the other, talking to him, seeking his thoughts and ideas on various issues, and watching the sort of glitterati of Delhi in action in front of his eyes. Mr. Sorabjee has been a huge inspiration for me personally. He has been an inspiration for hundreds of thousands of young lawyers, for young legal scholars, and the people that he has inspired is not just in India, but also across the world, particularly in Geneva, which is where I met him. I thank you very much, Ankit, and the General Society of International Law for having invited me. And may I join Dr. Rajkumar in also thanking Mr. Gopal Subramaniam for having agreed to deliver this wonderful lecture, which all of us are looking forward to listening to. Thank you.
Thank you so much, sir. And
Ankit, before you invite Mr. Subramaniam, I want to read something that Sorabjee had written about Justice Krishna Iyer. They were obviously very close to each other. And as a tribute to Justice Krishna Iyer, Sorabjee says the following. And he says, one outstanding human quality of Krishna Iyer was compassion. Compassion, not pity. There is a marked difference. Compassion is whereby we make others' misery our own, and which moves us to the relief of those who are in distress. His guiding star, his mission in life can be summed up in the moving poem by Emily Dickinson. And this is exactly what epitomizes Mr. Sorabjee as well. And I'm going to quote this. The poetry goes something like this. Quote, if I can stop one heart from breaking, I shall not live in vain. If I can ease one life the aching, or cool one pain, or help one fainting robin unto its nest again, I shall not live in vain. Unquote. That's Mr. Sorabjee's life as well.
Veena, ma'am, Veena auntie, as I know, ma'am, and I'll invite ma'am, who is also the founder of the Brilliant Stars non-profit school in the state of Tripura. She also serves on the board of directors of the Barley Development Institute for Rural Women in Madhya Pradesh, the institute which conducts programs on literacy, public health, vocational education for rural and tribal women. Ma'am, floor is yours.
Thank you, Ankit. I'm deeply grateful to Dr. Rajkumar and also to Ankit for having organized this memorial lecture in Soli's name. Truly, we have been associated with the Malhotras for many, many years. Ankit comes from the family of the Malhotra brothers, and we familiarly call his father and uncle the Malhotra brothers. And they have been most caring in looking after Soli whenever he went to London for a trip, and also in Delhi and any place in India that he went to. Soli was very fond of the India International Center. It was his second home, and he went there every day. And when Ranjit or Anil Malhotra happened to go to Pune to visit the daughter, they would not forget that Soli loved the Shrewsbury biscuits from the Pune Kayani bakery. So even though it was a very crowded place, they would go there and fetch the biscuits and give them to Soli. And he enjoyed them, though he was not supposed to, because they were all sugar and he was diabetic. But he never listened to us. He did exactly as he pleased. So Soli never controlled his diet. He would eat anything and everything that he enjoyed, and then take his diabetic medicines alongside. So Anil and Ranjit showed how much they cared for Soli, and Soli also responded the same way. I think he was present at all their book launches and released their books. I think practically everyone. And Anil and Ranjit like to remember that. Anil and Ranjit also would look after Soli when he went to any one of these diplomatic functions. And most times it was Ranjit and Anil who were wheeling him on his wheelchair into the function and let him enjoy himself as he could. I'm grateful to Dr. Rajkumar for having accepted Soli's books. When Soli passed away, I was wondering what we should do with his books, not the legal books. Those legal books went to Zia, but the other books was something that I was very worried about, and I didn't know what to do. So I called Dr. Rajkumar, and asked whether they would like to have Soli's collection of books. And they were in not just hundreds, but thousands. And he immediately agreed. These were the literature and poetry books that he had collected over the years, and other subjects also in connection with human rights, etc. So Dr. Rajkumar told me, he said, we will be very happy to have those books. And the next day, he sent his men. And within a short period of time, these men had managed to pack the books in about 74 cartons and wheeled them away in a truck. And the bookshelves were empty. I was really grateful because I used to ask Soli when he was alive, what shall we do with your books? Why don't you think, who do you want to give them to? And he would turn around and look at me and say, nobody is supposed to touch my books. And he was so particular about his books that if he saw a gap between two books, he would say, who has taken this book? And he would know the title of the book from which made the gap. And one day I said, you know, these books are really quite something. We've got to do something about that. Then he said, just fetch me the book that is blue in color and it's on the top shelf. We had to climb up to get that same blue book. He could remember the color of the book. He remembered the title of the book, and he asked for that book. Latterly, he couldn't read very well because his eyesight was giving him trouble. And so he asked me to read to him. And what he wanted every time was to be read to was to be or not to be. That is the question. So I would read that to him. And I found that when I started the sentence, he would repeat the last portion of the sentence. So he knew it by heart. But still he would want it read. Then, of course, he would want some poetry to be read. He would want some jazz to be played. We had an Alexa, so I would ask Alexa to play Benny Goodman for him and other musics that he liked. But he was getting frail and difficult for him to remember things. But that was something that was naturally, old age comes upon one, and we couldn't do anything about it. But I'm grateful to Gopal for having consented to be here. Gopal is Soli's senior junior, and we have had good times together with Gopal. He's been very, very sweet and very kind, and he was Soli's junior for some time. I'm sure he's doing very well himself now. He's a renowned lawyer, and I'm sure that many people go to him for their cases. So Gopal, thank you so much. Mr. Rajamani, I remember, was also very kind, but he was known to me under different circumstances. We needed an appointment with Mr. Yashwant Sinha, who was the foreign minister at that time, with regard to the persecution that the Baha'is were undergoing in Iran. And Mr. Rajamani said, you can meet him just outside the gate or inside the gate. I can't remember which it was. And so we waited for Yashwant Sinha to come down from his office, and Rajamani just introduced us, and I was able to talk to him for 2 minutes. And I hope that the matter went across, but that was the kindness of Mr. Rajamani. So thank you very much, all of you, for having been there, and especially for Jindal's having taken Soli's books. Truly, this is very, very much appreciated by the whole family. Thank you so much. Thank you. Thank you.
Thank you so much, ma'am. This is like a flash of memories go past me, as I was also part of these different occasions with uncle and my father and my uncle as well. I invite Zia ma'am to also say a few words, and then we will swiftly move towards Subramaniam, who will be talking on a very fascinating topic. Ma'am.
You're on mute, Zia. You're on mute. Just unmute her. She's on mute. Yes, that's
Okay. Very quickly, thank you so much, Raj. Really, really so kind of you to have this memorial lecture for Daddy. And to all of you who have attended, and to Gopal for his constant affection, which he can hardly stop containing for decades for my papa. And I will not forget how Gopal took Daddy to the hospital when Papa was not well and really cared for him like his son would have. So many memories, but you know, as I was telling my family after Daddy passed away, that the outpouring of love, affection, caring, respect that we received from people all over the world, it served almost like an anesthetic. That, you know, we could celebrate my father's life with such pride and the dignity of his life and the sheer power that he brought on to mold constitutional jurisprudence, which we hope will have had some impact. And I think Papa was proudest of his juniors. I think Gopal knows that. We always used to say that the USP of my father was the juniors he produced and the love that the juniors continue to have for him. So over to you, Gopal, and thank you so much, everybody, for making the time to come and hear everybody today. Thank you.
Thank you so much, ma'am. I will now formally introduce our speaker, Mr. Subramaniam, who is a senior advocate and practices in the Supreme Court of India. He is former Solicitor General of India and a noted scholar on legal philosophy, constitutional law, human rights theory. Having trained under former Attorney General Soli Sorabjee, Mr. Subramaniam was designated as a senior advocate, which is the equivalent of a Queen's Counsel in the United Kingdom, by the Supreme Court in 1993, where he developed a reputation for his rigorous style. He acted in numerous cases that have shaped legislative principles on privacy, human rights, and freedom of speech internationally. He successfully defended the conviction of the sole surviving terrorist of the 2008 Mumbai terror attacks, acted for petitioners in a historic case that held there is a fundamental constitutional right to privacy in India. And in 2013, he served on the J.C. Verma Commission, which recommended amendments to the Indian laws to safeguard safety and dignity of women and children. Having built an international leading name in the field of commercial arbitration in 2013, he set up an office in the United Kingdom and was appointed as an associate member of the 3 Verulam buildings. In 2015, he was appointed as a supplementary judge at the Qatar Financial Center Regulatory Tribunal. In 2020, he became the first Indian senior advocate to appear before the Supreme Court of Appeal. Outside of law, and perhaps most fascinatingly to me, is his work within legal philosophy, writing on democracy, social inequality, civic education, and the applicability of psychology to legal concepts. In 2019, he was selected to the Foundation Fellowship at Somerville College, University of Oxford. And he is a visiting professor to the University of Delhi and an honorary adjunct faculty professor at our beloved university. A classic music patron at South Bank Center, he is an ambassador of mental health charity, SANE, a fellow of the RSA, and honorary director of the All India Heart Foundation, the leading cardiac charity. In 2021, he was called to the Bar of England and Wales at Gray's Inn. Mr. Subramaniam, the floor is yours.
Thank you, Ankit. Professor Rajkumar, Ambassador Rajamani, Zina Sorabjee, Zia, and friends. I have begun to look forward to my lectures at the Jindal Global University, and as always, I'm delighted to be here. I'm more so honored to be speaking in remembrance of Mr. Sorabjee, who played a critical and pivotal role in my development as a lawyer and as a human being. As many of you may know, I began my career with Soli. My earliest memories are of him as a hard taskmaster, always forcing his juniors to their limits. He brought out the best in us. Observing him, I learned how to address the court, how to master one's brief, how to assist in matters as an officer of the court and not a mere spokesman for one's client. I look back fondly at a day not too long ago when I was prepared to open arguments before the Supreme Court in the privacy case. I was reassured by Soli, who sat beside me. I owed so much to his mentorship, and it was an honor to argue that case with his blessing. Soli lived with an unwavering commitment to his profession, with love for music and literature, and always guided by the belief that a successful future for India depended on securing rights to its citizens. He will live long in our collective memory, especially for his tremendous contribution to our jurisprudence on free speech and the freedom of the press. While his loss must be mourned, his great life must be celebrated. The beginning of this year saw strange happenings. A lady whose father was reminded by her cousin in the early 1950s that there is no place for women in the law, and the young girl was called to the bar in 1956. In 1976, she became the 10th woman to be appointed as a Queen's Counsel. She was the 3rd woman to be appointed as a High Court judge in 1979, following Elizabeth Lane and Rose Heilbronn. She was responsible for recommending a no-fault divorce, but the Divorce Dissolution and Separation Bill reached the House of Lords in the days following her death. I speak about Dame Margaret Booth, who died on the 1st of January this year. On that same day, a mathematician who was a specialist in number theory and representation theory, who made several contributions at King's College London, a member of the Institute for Advanced Study, died at the age of 73. He was the eminent mathematician Colin Bushnell. On that very same day, a French resistance member and a Holocaust survivor, Simone Chrysostom, died. She survived the German concentration camp at Ravensbrück. She was an extraordinary French stateswoman. On that same day, Mark Eden, who was a famous English actor, died. In fact, someone whose music may have attracted Soli, George Geddes, who was a famous American singer, songwriter, and actor, also passed away. We lost a famous French writer, Christian Mars, on the same day. So many passed away on the first day of that year, this year. April is a cruel month, said the poet. On that day, a day which I do not wish to remember, an eminent Indian cinematographer, K.V. Anand, a famous Indian actor, Vikramjit Kavarpal, a young bodybuilder, Jagdish Lal, passed away. When the news of Soli passing away reached, I remembered the lines of George Herbert. Death Thou wast once an uncouth, hideous thing, nothing but bones, the sad effect of sadder groans. Thy mouth was open, but thou couldst not sing. Therefore we can go, die asleep, and trust half that we have unto an honest, faithful grave, making our pillows either down or dust. Strangely, on that very day, Soli kept company with someone who came very close to his musical tastes, but in a slightly different genre of music. Anthony Edward Payne, an eminent composer and musicologist, was the one who completed Edward Elgar's Third Symphony. There is an element of modernized nostalgia when you speak about Soli. If Elgar's Third Symphony was incomplete at the time of his death in 1934, and all that which was available to Anthony Payne was 130 pages of sketches, yet in 1997, a musical called The Sketches for Symphony No. 3 was published. Great teachers not only contribute by personal example, but they also leave sketches which have to be filled up, hopefully, by those who either have had the privilege of working with them, or for that matter of fact, have been inspired by them. There are three similarities between Anthony Payne and Soli. All the three like Thomas Hardy, Tennyson the poet, and Philip Edward Thomas, the Welsh novelist. Soli strode across the corridors of court, always poised to make points tellingly, with precision and mobility. He will be always special for those who were influenced by his multifaceted personality, elegance, dignity, and unwillingness to abandon his principles. I remember Edward Thomas, whose famous words are so apt for Soli. Out of us all that make rhymes, will you choose sometimes, as the winds use a crack in a wall or a drain, their joy or their pain, to whistle through? Choose me, you English words. It looks as if the next few lines were the answer from Soli. I know you. You're light as dreams, tough as oak, precious as gold, as poppies and corn, or an old cloak, sweet as our birds to the ear. Soli was a protagonist. He could adopt the role of any client, put himself in the shoes of that client, and he could blend ruthlessness with wit. He was close to his roots, which was that he was truly an internationalist. He will always be remembered as one of the greatest sons of India, one of the greatest lawyers of all times, and someone who could constantly inspire. On the occasion of one of his birthdays, which was celebrated by all the leading members of the bar, the tributes which he elicited was something unique, special, and he was an artist craftsman who created individually every case, every point, and he covered all spectrums of litigation and constitutional thought. His legacy is enormous, which will inspire many further generations of lawyers. Soli was not shy of controversy. He was a great human rights campaigner. He was not a mere advocate, but a crusader for the high ethical standards of the legal profession. When he argued the Bhopal gas case for a review, an event which was justified as years of neglect and intransigence of government showed it. It matched the effort of Sir Harold Evans and my friend Marjorie Wallace in their campaign for the families of children who suffered birth defects as a result of the drug thalidomide. This occasion is rendered so memorable by the distinguished presence of Soli Sorabjee, a person who inspired and gave me a book called A Prescription for Living. The book is one which has stood the test of time and is so wisely written out of personal experience and conviction by a leader of the Baha'i faith. Zina is the person who actually makes the book come alive. Her presence on this occasion will always be treasured by me as a benediction both from Soli and her. Thank you, Zina, for taking the trouble to be present. It has been a singular honor to deliver this lecture before you. Zia, I can only say that Soli was not simply proud, but I think you added to his level of confidence and breeze. Only someone who was close to him would know how much he would remember you at slightly odd moments of reaching out for something which you would quickly remember. A very special daughter for a very special father. And I always remember Yeats' poem for his daughter. I think it completely fits you. I'll now turn to this topic at hand. I'm very honored that we have Professor Stephen Marks, somebody whose writings I have followed assiduously over a period of time, and I felt absolutely privileged to see him a few moments before this function started. Professor Marks is one of the few ideologues in the present day world who has been able to put together a synthesis, a syntax about the right to development, fundamental human rights, cultural rights, and the right to be free from poverty. He has actually taken unique positions in his writing, and he has brought to bear how important it is for students of law to know about the character of the right to development in international law. Apart from being a scholar on public health and his views during the raging pandemic, he is a model of inspiration and great intellectual rigor. I mentioned him in the forefront because nothing would be complete without acknowledging his contribution to the subject at hand. Like many students, I found international law fascinating. When I studied it over 40 years ago, I read Oppenheim, Brearley, Grotius, and Bentham with great interest. Brilliant as the subject was, there was a feeling that knowledge of international law would be of very little use in legal practice. It was believed that real lawyers must know evidence, interpretation, procedure. They must have a command over the Constitution, over company and criminal law, contracts and torts. International law was for the academic, not the litigator. I want to share this with all of you. Nothing could be further or farther from the truth. In practice, lawyers and courts regularly engage with international law in some form. This is as true in India as it is in the leading legal jurisdictions of the world. India's interactions with international law do not come as a surprise when one recalls that the very creation of our republic was an outcome of international law. The Union of India could be formed in 1947 over 560 princely states, each of them sovereign nations in international law, acceded certain powers to the dominion of India. These acts were followed by proclamations issued by the sovereign rulers of most of these states in 1949, accepting the Constitution of India in its entirety. In fact, it was on this very day, the 13th of August, 1814, that the Dutch ceded control over Cochin to the British Empire through another instrument of international law, the Convention of London. International and domestic or municipal law interact with one another in several ways. I quote a few examples. Courts frequently turn to international conventions whenever they are called upon to protect individual liberties. The same is true in matters involving rights to intellectual property. Courts are also called upon to interpret the terms of bilateral investment treaties between two nations while enforcing awards made in investor-state arbitrations. Principles of public international law, such as territoriality and sovereignty, interact with private international law when domestic courts issue worldwide asset freezing orders, thereby controlling the actions of defendants in foreign countries. Such issues also arise in cases of internet defamation, where courts are required, for example, to determine whether they can order a French company to take down web pages in France. Interaction with international instruments of what is called soft law is also common. Courts are, for instance, called upon to construe the International Bar Association's guidelines on conflict of interest in international arbitration while hearing challenges to arbitrators. Clearly, the scope of interaction between domestic and international law is vast. This is only natural considering the increasingly connected world we live in. Globalization demands constant engagement between states and their legal systems. How are we to view these engagements? Or more specifically, what is the relationship between international law and domestic or municipal law? When it comes to public international law, with which today's topic is concerned, two leading theories offer answers. As some of you would no doubt have studied, the first of these is the dualist theory, often called pluralism. It suggests that international municipal law are different systems of law that regulate different subject matter. International law governs the relation between states. Municipal law applies domestically, governing the relations of citizens with each other and with the state. Neither law has any power to alter the other. Where the two are in conflict, municipal law prevails. If international law is to apply domestically, it can do so through domestic law. For example, before the United Kingdom left the European Union, the EU treaties and law prevailed over UK law. This was not because international law automatically applied domestically. It was because of domestic law, the European Communities Act of 1972 permitted it to do so. A piece of domestic legislation thus enabled international legal instruments to apply domestically and prevail over national laws. The second approach is called monism, expounded by great jurists such as Hans Kelsen and Harsh Lauterpacht. For Kelsen, international and domestic law did not operate in distinct spheres. They were really a part of the same system of norms. Lauterpacht argued in favor of the supremacy of international law in all spheres, including domestic law. He distrusted the state as a protector of human rights and believed international law to be the best moderator of human affairs. India has always leaned towards the dualist approach. A notable illustration can be found in the judgment of the Supreme Court in Jolly George Verghese versus Bank of Cochin. The appellant was ordered to be arrested and detained in civil prison for his failure to pay certain dues to the respondent bank. The appellant argued that provisions of Code of Civil Procedure, which permitted detention in civil prison, were in conflict with India's obligations under the International Covenant on Civil and Political Rights. Article 11 of the ICCPR provided that no one shall be imprisoned merely on the ground of inability to fulfill a contractual obligation. Faced with this apparent conflict with Indian law, the appellant argued that the ICCPR should prevail. Speaking for the court, Justice Krishna Iyer rejected the argument, noting that until the municipal law is changed to accommodate the covenant, what binds the court is the former, not the latter. A.H. Robertson in Human Rights in National and International Law rightly points out that international conventional law must go through the process of transformation into the municipal law before the international treaty can become an internal law. Justice Krishna Iyer also referred to an earlier decision of the Kerala High Court, which dealt with the same issue, that is the conflict between the provisions of the ICCPR and the Code of Civil Procedure. This was the case of Xavier versus Canara Bank, where the Kerala High Court held the remedy for breaches of international law in general is not to be found in the law courts of the state, because international law per se, or proprio vigore, has not the force or authority of civil law till under its inspirational impact, actual legislation is undertaken. Following what is called the Doctrine of Transformation, these decisions seem to place India squarely in the domain of dualist theory. International law needs to go through a process of transformation before it can have legal effect in India. Once so transformed, it is not international law at all. It is in fact domestic law and can be construed and applied as such. The transformation Justice Krishna Iyer spoke of can be undertaken under Article 253 of the Constitution, which enables Parliament to make laws to implement any treaty, agreement, or convention with any other country or countries, or any decision made at any international association or other body. Parliament also has exclusive authority under the 7th schedule to legislate on matters concerning the United National Organization, the implementation of decisions made at international conferences, and to enter and implement treaties and agreements with foreign countries. However, as the executive's power is coextensive with that of Parliament, decisions on such matters can also be made by the Union Executive, provided they do not restrict or infringe citizens' rights or modify any existing legislation. It is important for us to bear in mind that the Doctrine of Incorporation does not prevent courts from making reference to India's obligations under international law. Courts can and frequently do rely on international law as an aid to the construction of domestic law. This is because Article 51, a directive principle that requires the state to foster respect for international law and treaty obligations in the dealing of organized people with one another. As Chief Justice Sikri said in his momentous judgment in Keshavananda Bharati, it seems to me that in view of Article 51 of the directive principles, this court must interpret language of the Constitution, if not intractable, which is after all a municipal law, in light of the United Nations Charter and solemn declaration subscribed to by India. Actually, it was the 1948 Charter which persuaded the Supreme Court in Keshavananda Bharati to locate the basic structure of an immutable character. Perhaps the most famous instance of the Supreme Court using international law to interpret domestic law is the case of Vishaka. The Supreme Court laid down guidelines to prevent sexual harassment and abuse at workplaces. In the absence of any domestic law in the field, the contents of the international conventions were, in the court's words, significant for the purpose of interpretation of the guarantee of gender equality, right to work with human dignity in Articles 14, 15, 19, 1G, and 21 of the Constitution. Clearly, even with the decision in Vishaka, international law did not apply proprio vigore. It had to be read into domestic law, thus forming a part of it. As such, it was really domestic law that the court was applying and enforcing. Our jurisprudence on the subject is, however, not without conflict. As a substitute to the doctrine of transformation, international law offers us the doctrine of incorporation. Under this doctrine, international law is to be considered a part of the domestic law and enforced as such. International law is deemed to have been incorporated into domestic law so long as it is not inconsistent with any domestic law. Conformity with the dualist theory remains only insofar as the supremacy of domestic law is untouched. In India's case, this would mean the Constitution would always reign supreme, for neither domestic nor international law can stand in its way. Support for the doctrine of incorporation is found most famously in Gramophone Company of India versus Birendra Bahadur Pandey, an excellent exposition of the doctrine by Justice Chinnappa Reddy requires to be quoted at some length. There can be no question that nations must march with the international community, and the municipal law must respect rules of international law, even as nations respect international opinion. The Committee of Nations requires that rules of international law may be accommodated in the municipal law, even without express legislative sanction, provided they do not run into conflict with acts of parliament. But when they do run into such conflict, the sovereignty and the integrity of the Republic and the supremacy of the constituted legislatures in making the laws may not be subjected to external rules, except to the extent legitimately accepted by the constituted legislatures themselves. The doctrine of incorporation also recognizes the position that the rules of international law are incorporated into national law and considered to be a part of the national law unless they are in conflict with an act of parliament. Committee of Nations or no, municipal law must prevail in case of conflict. National courts cannot say yes if parliament has said no to a principle of international law. National courts will endorse international law, but not if it conflicts with national law. national courts being organs of the national state and not organs of international law, must perforce apply national law if international law conflicts with it. But the courts are under an obligation within legislative limits to so interpret the municipal statute so as to avoid confrontation with the Committee of Nations or the well-established principles of international law. But if conflict is inevitable, the latter must yield. While decisions in support of the doctrine of transformation have not been overruled, the Supreme Court seems to have moved firmly in the direction of the doctrine of incorporation. Most recently, the doctrine finds acceptance in the decisions in Nalsa, where the Supreme Court upheld the rights of transgenders, and in Puttaswamy, where the court found that there was a right to privacy under our constitution. It must be stressed, however, that even while supporting the doctrine of incorporation, the Supreme Court does not say that international law is directly effective or enforceable in India. Courts only use international law as an aid to interpret domestic law, at times to fill gaps and at times to find implied meaning. In the case of the Gramophone Company of India, the Supreme Court used international conventions to interpret the word import in the Copyright Act. In Nalsa and Puttaswamy, the same was done to interpret rights in Part 3. As such, it is really domestic law that the courts continue to apply, just as they did under the doctrine of transformation. Acceptance of the doctrine of incorporation does, however, have ramifications in legal practice. As Ian Brownlee notes, the doctrine of incorporation represents a practical rather than theoretical policy in the courts. In my view, amongst its greatest practical benefits is in matters of evidence. Since international law is deemed to have been incorporated into domestic law, courts can safely treat it as law and not as fact. In the UK, India, and several other common law jurisdictions, foreign law, that is the domestic law of a foreign nation, is not law, it is fact. An English judge is not, for instance, considered competent to apply French law as he would English law, nor are English lawyers competent to argue French law as though they were French lawyers. Questions regarding what the law of a foreign nation says on an issue are therefore questions of fact that must be proved through evidence. This has been the settled position for centuries, one that can be traced back to Lord Mansfield's famous judgment in Mostyn versus Fabregas in 1774. In India, courts are required under the Evidence Act to take judicial notice of all acts of the UK Parliament. The laws of all other nations must be proved. In practice, however, Indian courts tend to be more flexible and often take judicial notice of legislation and court rulings from most foreign nations unless their meaning is disputed. The case is the same before international courts, which treat domestic law as fact. International courts do not take judicial notice of a state's domestic laws. They require evidence of it. Borrowing from the civil law tradition, where the process is not adversarial, judges may also undertake their own research to determine what a nation's domestic law says on an issue. When it comes to the application of international law in Indian courts, however, the case is different. Courts will take judicial notice of international law, though expert evidence can still be sought to settle disputed questions. And in construing international law, courts will be, as the Supreme Court rightly noted in Nalsa, Guided by Articles 31 and 32 of the Vienna Convention on the Law of Treaties, courts must interpret treaties in good faith and in light of their object and purpose. They may also rely upon connected instruments, subsequent practice in the application of the treaty, preparatory work of the treaty, and the circumstances of its conclusion. Indian courts also rely upon commentaries by leading authorities in international law. In a recent case involving the application of the Genocide Convention, the International Court of Justice quoted its advisory opinion rendered in 1951, and I quote those words: "In such a convention, the contracting states do not have any interests of their own. They merely have one and all, the common interest, namely the accomplishment of those high purposes which are the raison d'etre of the convention. Consequently, in a convention of this type, one cannot speak of individual advantages or disadvantages to states, or of the maintenance, a perfect contractual balance between rights and duties. The high ideals which inspired the convention provide by which you of the commonwealth of all the parties, the foundation and measure of all its provisions can be effectively discovered." Finally, I will turn to one aspect of today's topic. That is the role of lawyers. Lawyers occupy a unique place in interactions between domestic and international law. Usually, they are more likely than judges to have experience in dealing with international law. While judges are restricted, the freedom of legal practice allows lawyers to engage regularly with international law in all its forms. There is therefore a greater obligation to provide impartial assistance to judges whenever questions of international law arise before the courts. Counsel must work not only to win their case, but also to ensure the proper application of international law. This is especially important when courts are called upon to interpret customary international law, the rules of which are less easily discoverable. Courts tread on difficult terrain when different systems of law come together. The consequences of a single bad verdict can be grave, upsetting the hierarchy of norms that prevail under our Constitution. Lawyers must aim to ensure that the outcome of the case is coherent and legally sound. As the interactions between domestic and international law increase, there is also a need for a uniform global standard of ethics. Lawyers should not apply a different standard of ethical behavior before international courts and tribunals, while reserving a different standard for appearances before their national courts. Domestically, a global standard of ethics ensures a higher standard of advocacy. Internationally, it ensures that domestic judgments are met with the seriousness they deserve. Ethical practices are easier to form at the start of one's career. Years into practice, bad habits are far more difficult to shake off. As students, I would urge you to take international law seriously. You will engage with it at some point in your careers. Our interactions with it are only likely to increase in the years to come. And as governments across the world fall short in protecting the rights of their citizens or in ensuring an atmosphere of free and liberal inquiry, decades from now, we may even return to Lotte Park to conclude that international law really is the best moderator of human affairs. It has been a great privilege today to be in the presence of Professor Rajkumar, who is one of the most distinguished academics of the country and the world, Ambassador Rajamani, who again is not only a diplomat, but is a great thinker who also has written prolifically, including in his mother tongue, Malayalam, and of course, in the presence of Zina, as well as Zia. Zia, who is a chip of the old block, a part of the Skion, who actually today is a symbol of the ethical excellence in the legal profession. She's an icon today for everyone and those who wish to enter into the practice of law. Her industry, and she shakes off her brilliance with a certain unparalleled humility and concentrates on industry as a passport to success and resolution. It is such a pleasure and honor to be amidst all of you. And wistfully, I must say that if you find any credit in anything which I did in my life, it is for the person for whom this memorial lecture is intended to honor. Somebody who made a man out of me, somebody who gave me a vantage point of ethics, somebody who widened my horizons in all directions, somebody who endowed me with the purpose of life, somebody who taught me the value of humility and the need to abstain from criticism of others. Because as Soli would often say, look into yourself first. I miss him, and thank you for this opportunity.
Thank you so much, sir. It's been riveting hearing from you and your expert thoughts. I invite questions from our panelists and also our participants in this discussion. I would also like to acknowledge the presence of Dean Sudarshan and, as Mr. Subramaniam said, Professor Stephen Marks as well. We're open for questions now, but perhaps I could ask the first one on something that has just stayed with me and what I've read continuously is a quote by one Louis Henkin, who in his book, How Nations Behave, articulates the extent of compliance of international law. He said, and I quote, "Almost all nations observe almost all principles of international law and almost all of their obligations all of the time," end quote. Perhaps there exists a lacuna between application, compliance, and reverence for principles of international law. So what must be the role of a lawyer in an international setting to increase compliance of legal principles of an international nature?
I think it is very important to bear in mind that the genesis of international law is fundamentally humanism. And as you will, I'm sure, over the coming weeks, when you get to hear Professor Stephen Marks, the genesis of all international covenants is actually the human being. If we understand and grasp this particular facet of international law, then all these conventions and all these agreements, all these subscriptions which nations make seriously to international conventions will have a unique meaning. So the participation in international conventions is a step towards humanistic de facto equality. De facto equality is far more important than what we call as facial or a de jure equality, because ultimately the detail of the law lies in its application. When one looks at, let us say, the genesis of the right to development and the political turmoil and the resistance which accompanied it, it is fascinating to see how modern liberal democracies actually did not want the right to development be viewed as a sacrosanct human right. Because when right to development is set in the context of freedom from oppression and freedom from unlawful restraint, it acquires a certain meaning. These are all what we call as interlinked rights. The possibilities of interlinkage have happened today, like let us say the right to medicine at the time of a pandemic, or sharing of medicines in the interests of people who deserve medical treatment, are all emanations from international law. So international law, in fact, influenced our constitution tremendously. If anybody has gone through the either the complete works of Dr. Ambedkar or Sir B.N. Rao's papers, it will bear tremendous testimony that our Constituent Assembly participants were all influenced by the relevant principles which governed international law, and particularly the 1948 Convention as far as human rights is concerned. We must not forget that one of the companies which actually propelled this convention was one which recognized the importance of this convention. And if you read Malcolm Gladwell, he records it in his book, how Germany laid open the doors of all its archival records so that people could even discover what happened within their own families. And that was indeed the most telling discovery, where Germany found that human rights and the bulwark of protection was the fundamental obligation of the state. So therefore, one must understand that international law is founded in humanism. And particularly, it is meant to be agnostic to majoritarianism. It is meant to be agnostic to populism. It is meant to protect the rights of those who only want, as a part of their humanity, the right to freely express themselves. Therefore, I think international law has a very major role to play. It has a major role to play not only in the context of the language of rights, it has a still greater role to play in the language of duties of the state. What are the conditions which states are meant to engineer for the purpose of citizens or human beings enjoy those rights? That is an obligation of the states under international law. And thirdly, international law is the most veritable instrument of opinion formation in today's world. So it is a very, very significant subject. As you can see in the last 3 years, when you see the opinions and the orders which have been passed by the International Court of Justice, even in the context of the orders which grant provisional measures, you notice that the ICJ is taking the burden upon it to articulate the standards, which are the legal standards. But the legal standards are indeed a brilliant fusion of the common law and the civil law system. So the international law covenants are themselves a magnificent spectacle of the best in the common law tradition, the foundations of the rule of law, coupled with the desire for a civil law system to bring exactitude and precision to the table.
Thank you so much, sir. I, in fact, recollect Mr. B.N. Rao going on to become India's first judge at the International Court of Justice, and perhaps the German sagacity, which remains perhaps most profoundly in Willy Brandt kneeling in Poland and accepting what has happened. I now invite our Vice Chancellor to share his thoughts and comments. So,
thank you very much, Mr. Subramaniam, for that fantastic lecture, which is thankfully we've recorded it. So I know that every student or faculty who missed it will enjoy watching it again. I want to take you back to a book written by Anthony Kronman, who used to be the Dean of Yale Law School. And the title of the book was called The Lost Lawyer. It was published by Harvard University Press. And in that book, Anthony talks about the notion of a lawyer statesman, as a kind of an idealized lawyer figure possessing great wisdom, exceptional persuasive powers, of course, deeply committed to moral engagement, practical wisdom. And obviously, Mr. Sorabjee epitomized all of that. So my question to you is that this idea of a lawyer statesman, has it, at least when you look at the Indian context and today's bar, is it fair to say that it is a rare commodity, a dying breed?
One has to be optimistic, but I would definitely say one thing, that the moral grammar, which Soli was a symbol of, was also a part of the tradition in India. So if you look at, let us say, look at the law officers, an Advocate General of Bombay was invited by the Home Minister to be the first Attorney General, Mr. Setalvad. Mr. Daftare, who was the Advocate General, succeeded him as the second Attorney General. And you will notice that when Mr. Sorabjee came in, and I'm now talking about the time when the Janata government came in, again, a person of great reputation like Mr. S.V. Gupte was requested by the Prime Minister of India to be Attorney General. Now, all this actually underscores the stature, which is not simply a matter of perception, but there was a practice of moral grammar in the practice of law by these individuals. And I must say that Mr. Sorabjee and Mr. Palkiwala, Mr. Falinariman, all of them maintained the highest of traditions. They had differing styles of advocacy, but they maintained a certain moral grammar. It would be unwise to say that the grammar has not influenced lawyers of the present day generation. That may not be an accurate statement. It has influenced lawyers of the present generation. But shall we say the conspectus of the law being a profession and law being more of an entrepreneurial activity, both of them have actually come to stay. And sometimes there can be a conflict between both these perspectives. But the lawyer statesman is the best form of assist for a court of justice in India. It requires a lot out of a lawyer to be like that. It requires constant redefinition. It requires a perpetual sense of dissatisfaction with oneself. It requires constant striving. But I think it is worth it.
I now invite Professor Ambassador Venu Rajmani for his question.
Thank you, Ankit and Mr. Subramaniam. Thank you so much for that wonderful lecture. My hat's off to you and tributes to you for being such a wonderful champion of both international law and the right to development, subjects which I am a student of and I'm passionate about. I have one comment and one question. My comment is, I have in Geneva fought for the right to development. Inch by inch, one had to break down the resistance of Western delegations. And it is unfortunately the lawyers who come as part of Western delegations, the American lawyers being the worst of the lot, who saw always civil and political rights as something of a watertight compartment, which should not be diluted under any circumstance. And we used to, or at least I used to consciously point out to them that the Universal Declaration on Human Rights talks about freedom from fear and freedom from want without any sense of hierarchy. Both exist, both coexist. And you cannot just have freedom from fear. You must have freedom from want also, if truly you have to establish justice. And we used to talk a great deal in forums in Geneva about the pioneering work done by the Supreme Court of India to liberally interpret fundamental rights, to also incorporate within it economic, social, and cultural rights to a large extent. This is my comment. But my question was, there are still many, many areas in which, in my opinion, the Indian state has been very timid in bringing international law into our domestic law. And often human rights has suffered, individual rights has suffered because of that. One classic example is refugee law. We still do not have a refugee law in our country. We only have the Foreigners Act, and it is very arbitrarily applied as and when it pleases the government. The Supreme Court and other courts have tried to intervene. They have tried to ensure that any person using the provision that any person on the territory of India is entitled to a certain minimum of rights. They have tried to expand the scope of the rights that refugees who cross into India actually enjoy. But that still is not enough. Even now, we are getting reports of Rohingya refugees being pushed back. Another classic example is the Convention Against Torture. The Convention Against Torture, we all know how rampant, perhaps, torture is prevalent in India, in the Thanas, in the Mufassil village areas. And we have just not bothered to bring it into domestic legislation and try and create a national sustained mission to eliminate torture within our country. In areas like this where the state will is lacking, do you think the Supreme Court and the courts can be even more progressive in their interpretation and can they expand the scope of the law even further through their judgments?
I think it's a brilliant question. I think they can. I think they ought to. I think that is the need of the hour, because of the fact that in our jurisdiction, when the Constitution was framed, as you said, and Dr. Ambedkar's works completely reveal his, I think he was a great anthropologist, apart from being a great draftsman. They reveal the connection between freedom from want, freedom from fear, and the two instances which you said, whether it be the non-adoption of the principles of reforma in respect of refugees, or in respect of, let us say, a commitment never to practice torture. Both these are areas which I think at least one can see in Dr. Ambedkar's Trevor Prepartwas for the Constitution, that he was fully alive, that we must have a constitution which is a dynamic constitution or a living constitution, and is not a constitution which is an originalist constitution, but which is going to actually adapt itself to needs of time. And I think the needs of time also have another conspectus to it. The whole idea of international law is that a state which exercises sovereign power must still be accountable under a higher legal order, which is international law, because human beings are still paramount. They survive despite the state, in spite of the state. Therefore, international law was indeed a moral dimension as far as commitment of states is concerned. The point which you made about the UN Charter, the 1948 Charter was actually the key to Keshavananda Bharati judgment, because the Supreme Court said that, look, we consciously have a constitution which embodied republicanism, democracy, free and fair elections, and a certain set of rights, a certain rule of law. It had to be necessarily immanent. And that was the reason why we enacted a constitution. So the reflection of the international covenants, and particularly, as you said, in the context of right to development, and Professor Mark speaks about the 4 different groups and all that, some of them opposing this as a rhetoric, but there is a lot of vested interest, I must say, without blinking an eyelid, that states do not want to be seen as subscribing to this because levels of accountability are much higher. So when the states do not wish to subscribe to, say, a convention against prevention of torture, or when they don't want to subscribe to principles of reforma, then courts are not powerless, because courts in India, and particularly when we talk about fundamental rights of citizens is on one hand, but even human rights of persons is guaranteed under our constitution. So therefore, courts, I believe, have not only a proactive duty. It is not that they are overstepping their limits. It is not that they are trespassing into the territory of the legislature. But it is a solemn obligation cast on courts under the Constitution to discover the gaps and see whether there exist valid, judicially manageable concepts of law. Now, reforma is a concept of law. Reforma is not arbitrary. So when Aaron Barak speaks about how principles of international law engage him, even in seeing about the restraint on human liberty, he is using well-known principles of legal order. And as I said, the advantage of looking at these conventions is that they are a very unique amalgam of the common law tradition and the democratic principles underlying the common law tradition with the desire for exactitude in the civil law systems. So I think the courts have adequate principles. As long as they can trace it to a principle, I think they're certainly at liberty. I personally think they're under an obligation to support these positions. Thank you.
Thank you so much, sir. I now invite Professor Stephen Marks. Professor, the floor is yours.
Thank you so much. I don't want to detract from the other people who have questions to raise, but my name has been mentioned far too often in this, and I want to protest. So I'm raising my hand in protest with the excessive references to my own role, but I want to do that in drawing attention to the members of this society and to the students at Jindal Global Law School that you've just heard from a master. You've just heard from one of the great minds of international law. And one of the things that you've probably already learned, that you will learn, is that in your understanding of international law, the core concepts that constitute the starting point for all that you will do in international law are to understand the subjects of international law and the relationship between municipal law and international law. You couldn't get a better articulation of that. Another brief observation on the right to development. A few weeks ago, the Intergovernmental Working Group on the Right to Development met again and over the draft convention, and it's in a complete stalemate. We've gone back to the worst era of the politicization of this, with the NAM on the one side, the Western group on the other side, and then a group of Latin American countries abstaining. It's unfortunate, but I do remember being in Geneva with the wonderful diplomatic team there with Arjun Sengupta at a period when there was, in fact, the beginning of the coming together of the groups. In fact, when we presented our report with Arjun, it was the EU that was the first to compliment us, and the African group was scratching their head saying, there must be something wrong here. The EU is favoring this. So it is unfortunate the direction that the right to development has taken, but it does represent, and Subramanian was absolutely brilliant in expressing to you the relationship between the monist and the dualist understandings of the role of international law in the practice of the domestic judiciary. So I want to turn this now into a question. On that subject, the sad reality is that we, of course, belong to what we might call a cosmopolitan tradition or a liberal internationalist tradition or a constructivist tradition in terms of international relations. And we're acutely aware that politicians and diplomats often act on a more realist or neo-realist approach to understanding this relationship. And what I'm getting at here is the trend of authoritarianism in which major countries, I could list them, but you can as well, are taking the position that they want no lessons from any other countries or any international institutions. This reinforces the strong position that many governments are taking, and they're putting their own judiciary in a very dangerous situation of essentially discouraging them or even punishing them from from applying norms of international law, however humanist they might be, and you're quite right of how humanist they are, of applying them in the interpretation and the application of domestic law. So my question is, where are we heading? Is this authoritarian tendency undoing all that we have tried to build up in reinforcing the application of international law in the interpretation and application of domestic law? Thanks.
I think it's a very perceptive remark, because authoritarianism undermines both constitutional normativity, which is embodied in a domestic constitution, but it also has a serious ricocheting effect of undermining international obligations. I'll give you one example of why international law is so very important and why it is founded on humanism. Many years, I mean, it was some time ago when I read, it was, I think, 216 Harvard Law Review, I guess, page 1. I saw that 78 to 85 pages by President Barack Obama, where he listed what concerned him in the criminal justice system. Now, normally, one would think a criminal justice system is a matter of localization, or it is something which is within a country. But when I read how he was led to changes in the law, it was very clear to me that he was co-opting to follow concepts which lay in international law, concepts of freedom from unlawful restraint, concepts of access to justice, which again is a part of major work in international treaties and conventions. So wherever we find that people are willing to embrace ideas and values which underlie international law, I think it's an investment which such people make for the well-being of their country for periods and times to come. Actually, millennium goals are these. The millennium goal really at this moment has got to be rewritten as freedom from autocracy, or freedom from narrowing down what are called the boundaries and the frontiers of our own imagination and about the discourse of rights. You know, the two words which you said, the two adjectives, the liberalist tradition and the constructivist tradition, unfortunately, liberalism itself has acquired a pejorative connotation. But the word constructivist, fortunately, still has not come to be rubbished. So even the word constructivist, I think, is so meaningful that the windows which international law gives in the development and understanding of constitutional law and societal obligations, both between members of a society inter se and also the society and the state. It is a fascinating paradigm. And that is given only by reason of the emerging nature of the discourse in international law. When we see, let us say, we see the Trevor Prepatwa of a CEDAW report, or when we see even what went on in the right to development debate, we then see where are the voices coming from. And we see this close connection between freedom from poverty and the need to make rights realizable. So actually, there is a gentleman in Cambridge. You might be very familiar with his work, Professor Parthasarathi Dasgupta. So Parthasarathi Dasgupta, he's an economist. He actually, again, it's a brilliant theory. Somebody, I mean, I feel he's never got the full credit he deserved. But the theory which he rarely articulates so brilliantly was, he said, in empirical development, in terms of GDP, do you factor environmental costs? Do you factor costs in relation to cultural impact? Those also must be quantified and netted against your GDP. So you have, even in economic terms, you must develop a calculus by which you give a number for impact studies. And I think it's a it's a brilliant point. I've never been able to leave that line of thought. It's one of, for a person who is an economist, to enforce ideas of accountability. Somewhere I see Arjun Sengupta also echoing some parts of it, but not so close to it as a realistic treatise. But it tells us how people are thinking of the human condition. For instance, index to human happiness. Now, most people initially rubbished it. They said it's all subjective states of mind. But now COVID has taught us that all this can be actually calculated with reference to multiple parameters about mental health. You have a checklist. For instance, in England, for the purpose of dealing with, say, the problem of dementia. Now, dementia is a neurological condition, but considering the number of women who die due to dementia, the scientific studies, including empirical data collection, has been on the upward swing. And now people are looking at, shall we say, all empirical steps which are required to offset the progression of a disease. So disease has multiple connotations. Some of them may be neurological in a person's body, but some of them may be in a societal psyche, which also need to be addressed. That is why the greatest invitation, I think, which I hope the General Global Law School will undertake, is the rule of engagement and the rule of dialogue, because there is no other way than our getting heard. And we have to be persuasive. We have to make people change their points of view. We have to, behind power, behind the throne of power lies, I think, a larger ocean of humanity, which requires to be severely addressed, severely catered for. And they're all, each one is equal to the other, is equal to the third. It is simply equality.
From one dean to another dean. Mr. Subramaniam, we now have Professor Dean Sudarshan of the Government and Public Policy School. Professor Dean Sudarshan, the floor is yours.
Thank you very much, Ankit. It's been a very moving and intellectually stimulating occasion. And I'm very glad that I could join this because of my friendship in a small way with Soli Sorabjee. When Rajkumar was selected for the Rhodes Scholarship in 1997, and Soli was the chair, I was sitting next to Soli Sorabjee. He mistook, Rajkumar was so brilliant, and Soli had the back of his mind, because of the recent Rhodes Scholars before him, that the National Law School, Bangalore, was the only one that could produce such articulate, impressive person. So he got it into his head that Rajkumar was from the National Law School, Bangalore. And I had to keep nudging him and point out that he's from the campus law faculty of Delhi University and from the National Law School. And I've had many contacts with Soli. Also, when I worked in the United Nations Development Program, and we ran into difficulties with the finance ministry that wanted all the grants of the UN system to go through the government. Soli was a great help in preparing a note saying that the Consolidated Fund of India, that it was not necessary for the government to receive the money, but it could direct the use of the money without actually receiving it into its account. Now, which is a very sensible proposal. And unfortunately, the finance ministry said Mr. Sorabjee's opinion is not administratively expedient to implement, and they didn't follow that advice. So in all of these matters, I've had contact with Soli, and I'm very touched and moved that we are doing this in his memory. Stephen Marks is here. My question was really about, in 1987, 88, Justice Bhagwati convened a group in Bangalore of all the chief justices of Pakistan, Malaysia, Zimbabwe, Sri Lanka, and Nepal, and so on, and drafted, and Michael Kirby was then there. He was in the Australian Law Commission at that time. They drafted the Bangalore Principles on the domestic application of international human rights norms. Now, I've seen, there was such enthusiasm for that, and I was very happy to be part of it. I was in the Ford Foundation as a program officer, and so was Steve Marks at that time in the Ford Foundation, and supported it with the Commonwealth Secretariat involved in it. Now, I've seen that Michael Kirby, after he became a judge, made frequent references to the Bangalore Principles in judgments, and said he will, adopt these norms, these principles. But I haven't seen our judges, post that era of judges like Krishna Iyer, but Justice Bhagwati, Chinnappa Reddy, D.A. Desai. There hasn't been that kind of, curious interest and an innovative way. As Gopal Subramaniam pointed out, the Keshavananda judgment is absolutely fantastic. Upendra Bakshi says it's giving us a new constitution in a sense, and that kind of creativity seems to be missing. And this is again, Venu raised this concern, because in times of creeping autocracy and challenges to democracy and rights, we must look to judges to at least, we haven't got to that state where, judges are rounded up and sent off to prison. We haven't got there, and therefore there's still a large amount of respect and legitimacy that the public confers on our judiciary. And I wish there was a little more courage in the courts, and I wish the bar would somehow motivate these judges to say follow the Bangalore Principles on applying domestic application of international human rights norms, and break new ground. So those are the thoughts that occurred to me. I'm very grateful to be part of this group. Thank you.
I think it's a very valid point which you made about the Bangalore Principles. I find it that it was a unique exercise. Unique. It was again a powerful statement of self-definition for a judiciary. Now, it was actually a very well thought out set of principles. What struck me as very, very strange is many jurisdictions have adopted the Bangalore Principles in their law. The UK has adopted the Bangalore Principles as a part of their idea of judicial independence. It is referred to as Bangalore Principles. So Bangalore Principles was one of them, that the emanation of those principles was really a very original, very creative act of self-definition. And Michael Kirby, of course, I must make a disclosure. He's been one of my very dear friends and a great thinker who has also influenced me in looking at many aspects of human rights. But the important part of understanding Bangalore Principles is the purpose of those principles was not only for self-definition, but objective yardsticks of judicial behavior. And more importantly, the correlationship between those objective yardsticks and public trust in the judiciary was interlinked. So the connection which the principles made was that if a judge had a deed of adherence internally to these principles, then the net product which would emerge would be a greater confidence. Public confidence would be much higher. I would not say that our judges are oblivious to those principles. That may not be a fair statement, but I think the self-affirmation of those principles is also a very dynamic exercise. It is like somebody needs to remind one's own self all the time. It's a form of mindfulness for judges. So if mindfulness was a metaphor which I could use, then the Bangalore Principles are definitely very helpful in enhancing mindfulness, which itself, any form of mindfulness can lead to a better judgment. Any form of mindfulness can lead to a higher state of empathy. Any form of mindfulness could even lead to transformative consciousness. Very often what we call in the language of psychology as the act of transference from one person to the other. And judges needed, the Bangalore Principles actually knew that transference was the key for judicial dynamism. Now, how do you achieve it? Unless you have these firewalls, if I were to borrow, let us say, a computer, a hardware word, unless you had these firewalls, the Bangalore Principles were those firewalls. And I think they are very useful navigators. They make the individual subservient to higher principles, higher causatory principles of human trust. And since these are causatory in character, and it's a matter of great pride for India that Bangalore Principles have been adopted in so many jurisdictions as a part of their defining judicial conduct. So I think at all points of time, Bangalore Principles is really, it is the architect of the definition of a judge. And there's one other footnote which I wish to add, that there is a belief about the hierarchy of courts. It is somewhat overstated, in my view. Constitutionally speaking, while one could think of an appellate forum, you say High Court as an appellate forum, you say the Supreme Court as an ultimate appellate forum. But in reality, if one studied the subtext of the Constitution, there was a contemplation by the Constitution makers in Article 32, sub-Article 3, which enabled Parliament to authorize courts other than the High Courts with the same powers and functions as those of the Supreme Court under Article 32, which means the Constitution makers had in their vision a brilliant trilateral judiciary, which meant the district judge was as good as the High Court was as good as the Supreme Court, or Supreme Court vice versa. In other words, the comparability was meant to be very, very marginal. The standards had to be more or less uniform. So a point which I read, of course, in my colleague, and of course now the learned judge was retired, Justice Rohington Nariman, when he spoke about the obligations of the state to people in the matter of appointment of judges. He has said something, I think, absolutely wonderful, and it needs to be taken to heart. It is consistent also with the Bangalore Principles. Namely, that the obligation is meritocracy. The obligation is people are entitled to demand the quality of judiciary defined by Bangalore Principles, which is meritocratic. So the principles themselves actually promoted meritocracy. If one reads the subtext of those principles, and incidentally, Professor Sudarshan, I must tell you that when they have the questionnaire for judges in many jurisdictions, because it is being done through the system of a commission, if you see the detailed questionnaires, the questionnaires have been framed in such a way which have to be filled by an applicant so that the committee can decide whether there is adequate evidence of these characteristics in his personality. It's very objectively determined. It is not on the basis of a subjective opinion. So when those functions are being even undertaken by, say, judicial bodies like the Collegium, the requirement is always to keep in mind Bangalore Principles as objective criteria by which you can discern meritocracy. So it's a very valid point, although the learned judge said it when he was demitting office, but he himself was an embodiment in his own distinguished career as a judge of the values which underpinned the Bangalore Principles. He was he was a colossus according to us, a man of such great intellect and austerity. There was a combination of both, which again is a part of the product of Bangalore Principles. So when you speak about justices like Justice Michael Kirby, and I'm sure that history will one day place, hopefully, Justice Nariman in the same bracket for his own positions, I think there is a lot to be said that principles are about the individual. There is nothing called, although there is a saying, a man can be taller than his office, but in reality, the judicial office requires the man to be far more subservient. And there is an inverse proportion, if I may say so, that those who have been humble have been greater by the yardstick in terms of their creativity as judges. Those who have been diffident, now, for instance, not many people would record this, but Justice Bijan Mukherjee was often perceived by many, those who appeared before him, who told me, he looked always a bit diffident, very humble, a little unsure of himself, but the end product was perfect. So there is an element of humility, the ability to be cognitive of two different points of view and not go by your tastefulness of either of them. It requires a different skill play, which is what the Bangalore Principles are also part of the Australian fabric, not only England. I mean, they're a part of the fabric all over. So except for countries which follow a totally Montesquieu model of separation of powers, where they think it is a management function to keep people in their respective domains. But barring that, I think the judiciary has become very progressive as far as the Bangalore Principles are concerned. Singapore, for instance, has had traditions where judicial independence and competence has also been attributed in some measure to the Bangalore Principles.
Supreme, but not infallible. Thank you so much, sir. It's been an honor and it's been a delight. You started with remembering Alfred Lord Tennyson, and one thing that I have gained by studying in Jindal is to not only read languages but also literature. And I'd like to quote Tennyson, and these words have stayed with me in my studies in law school. And I quote, "Though much is taken, much abides, and though we are not that strength which in old days moved heaven and earth, that which we are, one equal temper of heroic hearts, made weak by time and fate, but strong in will to strive, to seek, to find, and not to yield." With those words, I thank everyone over here, and I offer the virtual floor to our Vice Chancellor to offer the closing remarks. Sir.
Thank you very much, Ankit, and thank you so much, Mr. Subramaniam. What an extraordinary lecture, but also the wonderful set of reflections, responses, comments. I think it is an understatement that everybody who has been part of this exercise would have been deeply inspired. So I'm very much grateful to you. We can't wait to welcome you back for the first Professor Roger Hood Memorial Lecture, which you will be delivering soon. So thank you very much for accepting that invitation as well. Thank you, Sudarshan, Benu Rajamani, of course, Steve and Ankit, and all the others who have been part of this panel. And in closing, I want to say on a more serious note, Mr. Subramaniam, since you are in London, I would encourage you to locate this beautiful and fantastic cookie shop known as the Ben's Cookies, and eat them and allow us to have the vicarious pleasure of those wonderful cookies, which are originally from Oxford, but also is located in London as well.
Your partiality to Oxford shines through.
I know. Thank you so much. Great.
Thank you very much indeed. And it was such an honor to mix with everybody and to have these reflections. It was really scintillating. Thank you so much.
Thank you. Thank you. Thank you.
Thank you so much. Thank you, everyone.
Thank
you. Bye-bye.
Thank you.
Well done, Ankit.